Chapter 26, Injunctions for the Protection of Water Rights. Section 561, Pollution. Injunctions to protect water rights are very common illustrations of equitable intervention because of the inadequacy of legal remedies. The principles governing the equitable jurisdiction are essentially the same as in nuisance, the legal wrong being in the same class of torts. For a more detailed statement of these principles, therefore, reference should be made to the preceding chapter. Herein are simply stated the more general rules as illustrated in the cases on water rights. Pollution of running waters is a matter of frequent injunction. The grounds of the jurisdiction are to prevent multiplicity of suits because of a continuing or recurring wrong, or to prevent irreparable injury, or the fact that the damages are not susceptible of estimation, and hence a verdict would be in the nature of conjecture. It is usually held, too, that it is a taking of property, and hence cannot be authorized by statute except by way of eminent domain with proper provision for making compensation, and even then it would not be constitutional if the taking is for a private purpose, and equity may enjoin for these reasons. If the pollution is only temporary and occasional, it will not be enjoined. It is the general doctrine that, since riparian owners have the right to have flowing water come to them in its natural purity, and so may bring repeated actions at law for pollution, even though it causes no damage, therefore equity will enjoin such pollution, regardless of the question of damage, in order to prevent multiplicity of suits. If the nuisance is a public one, a private plaintiff can procure an injunction only upon showing special damage to himself. It is no defense to a bill against one for pollution of a stream that others are also polluting it. Nor, by the better authority, is it a defense that granting the injunction will harm the defendant more than refusing it will harm the plaintiff. Having taken jurisdiction to enjoin the continuance of pollution, equity also awards damages on the principle of giving complete relief. Section 562. Diversion or obstruction. It is a clear principle in law, that the owner of land is entitled to the use of a stream of water which has been accustomed, from time immemorial, to flow through it, and the law gives him ample remedy for the violation of this right. To obstruct or divert a watercourse is a private nuisance. The remedy by injunction which equity affords is very frequently sought. And the foundation of that jurisdiction, said the court in the same case quoted above, is the necessity of a preventive remedy when great and immediate mischief, or material injury would arise to the comfort and useful enjoyment of property. The interference rests on the principle of a clear and certain right to the enjoyment of the subject in question, and an injurious interruption of that right which upon just and equitable grounds ought to be prevented. If this oft-quoted language means anything more than that diversion of water will be enjoined when it is irreparable, or when, from its continuance, it would involve repeated suits at law to furnish redress to the plaintiff, and that generally the case will fall within one or both of these familiar heads of jurisdiction, it is believed the authorities do not support it. Diversion of water is not per se a thing that will be enjoined. It may, however, be enjoined without a showing of damage, but this results from the fact that at law the plaintiff may maintain an action without proof of damage, on account of the invasion of his right to have the water flow in its accustomed channel, and equity will enjoin under the same circumstances in order to avoid repeated litigation. Another ground of jurisdiction may be that, though the injury is not irreparable in the sense of being one of such peculiar character that money will not pay for it, yet the amount of damage is incapable of ascertainment in amount, and equity will not leave the plaintiff to a verdict at law which cannot be measured by any certain pecuniary standard, but must be based on conjecture. Such a legal remedy is not adequate. A diversion which is only threatened, and not yet existing, if imminent and likely to cause irreparable injury, may be enjoined. A diversion of water no greater in quantity than an amount which the defendant introduces into the stream above, will not be enjoined, as the plaintiff has no property in the water itself but only in its flowing, and this may be the same though the water is not the identical fluid naturally in the stream. In jurisdictions in which prior appropriators' rights are recognized at law, they will also be protected in equity. It is held that in determining the propriety of an injunction the balance of injury between the plaintiff and the defendant will not be considered. In addition to an injunction, equity will also give damages for past diversion. If the defendant is a municipality or other body having the right of eminent domain, The decree may be so framed as to allow for the making of compensation instead of an unconditional injunction. Riparian owners on non-navigable lakes have rights in the water such that they may enjoin draining or other diversion of it. Cases of injunction against diversion of water other than those already cited are collected in the note below. Obstruction of running water is a wrong of exactly the same character as diversion, being an interference with the riparian owner's right to have the stream in its quantity and manner, and as a subject of injunction, is governed by the same rules. Section 563. Percolating Waters. As a result of the legal rule that one has no rights in percolating waters as such, it follows that equity will not interfere with their diversion or obstruction, even when the effect is to cause a spring or well of the plaintiff to dry up or diminish in flow. But it has been held that one can thus take percolating waters from his neighbor only for use in connection with his land. Hence taking it simply to waste it or to sell it to a city for municipal purposes has been enjoined. Neither does the doctrine concerning percolating waters apply to subterranean waters flowing in a defined channel, and interference with their flow may be enjoined by a person injured, as a prior appropriator in the jurisdictions where rights of appropriation are recognized, or a person lower down on the channel. Nor can a person by means of percolation interfere with the flow of a stream. This is no less a diversion than if he took the water directly from the stream by a ditch or other channel, and will be restrained in equity. The right to interfere with percolating water is confined to diverting, obstructing, or abstracting it. If one pollutes it and in this condition it injures another, as by flowing into his well, it is a nuisance and as such may be enjoined. And the same thing is true if one causes water to percolate into the land of another and cause injury. Section 564. Obstructions to navigation. Obstructions to navigation of navigable streams are, of course, primarily public nuisances and as such subject to indictment or restraint at suit of the proper public officer. If the obstruction is in tidal or other waters in which the state is the actual owner of the soil, it may be one which causes no injury to anyone. In such case it is not a nuisance but simply a perpressure, which is an intrusion upon the proprietary rights of the state, or crown, which may be remedied by an information of intrusion at common law or an information in equity at suit of the Attorney General, and, in the latter event, it is said that the Court of Equity may refuse an injunction if the perpressure does no damage to anyone. If, however, the obstruction actually interferes with navigation, it is a nuisance as well as a perpressure, and in this aspect it is subject to the usual rules concerning public nuisances. It may be enjoined at suit of the Attorney General or other proper public officer on behalf of the state, if the legal remedy is inadequate. If the question whether a nuisance exists or not is doubtful, a suit at law to establish the fact is required. Such nuisances may not only be enjoined by the proper public official, but also by a private individual who shows special damage to himself and that his legal remedy is inadequate.